that one. That one was very informative as well. So we are privileged to have them here and honored that they have come out to do this for us. So let's give Magistrate Steve Elliott a hand. And I appreciate Tara back here as well. She is with him. And we're going to hand it over to you.
Thank you. Thank you. And thank you, everybody. I'll say this up front. So Elliott Kolkovich, our prosecutor, came and did the scam presentation. I'm Steve Elliott. This Elliott's better than that Elliott. Just remember that. But I'm Steve Elliott. I'm Chief Magistrate of the Summit County Probate Court. I've been with the court about 7 years. In fact, 7 years and 1 day today. So I became chief about 2 years ago. Prior to coming to the probate court, I was a practicing attorney for 15 years here in Summit County. Did a lot of estate planning, probate work, civil litigation, real estate law. We were in a small firm, so we did a lot of different things. Prior to that, I was in law enforcement. I was a parole officer for the state of Ohio for about 4 years. And I also worked at the CIA down in Washington, D.C. for a couple of years as well. So kind of a weird route to get to probate court, but that's where I am now. So I said I was chief magistrate. Who here knows what a magistrate is? Okay, that's more hands. I saw some go like this. That's more than I usually get. So when I was practicing law, Judge Stormer approached me and asked me if I'd want to come be a magistrate in the probate court. So I went home that day and I told my kids, I have 3 kids. They were all teenagers and younger at that point. And I said, hey, I'm not going to be an attorney anymore. I'm going to be a magistrate at the probate court. And I said, do you guys know what a magistrate is? And they all looked at me just like you guys did. And so I said, Judge Stormer is the elected probate judge in Summit County, but she has 4 magistrates that kind of help her. I said, I wear a robe, sit at the front of the courtroom, sit up on the bench, I make decisions, I have hearings and trials, and I do everything that she does, but she's the judge, and I work for her. I have my own caseload and do everything she does. And they said, so you're a mini judge. So if you remember mini judge, you'll remember what magistrate is. And that year for Christmas, my kids actually bought me a mini gavel Christmas ornament and still hangs on our Christmas tree. So who here has been to the probate court before? There's a couple more hands there. Who here has been married before? All of you have been to the probate court. When you hear probate, a lot of people think death, estates, trusts, maybe guardianships. We do way more than that. We handle over 200 different kinds of cases. We say we're the court of new beginnings and endings. Some of the cases that we do, we finalize adoptions, starting a new family. We issue marriage licenses, like I just mentioned, so starting life with a new spouse. We also conduct all name changes. So if you have to have your name changed, or if you have to get that travel compliant driver's license, and your birth certificate doesn't match your driver's license, you might have to do a name change with us, so keep that in mind. If you're going through that process, it's painful. But then we say that court of endings as well, obviously the things you think about when you hear probate, estates, guardianships, those types of things. So we do a lot more than what people normally think that we do. So when I was doing estate planning work, I did a lot of it. I would sit down with a client when they would come in for a will or a trust, whatever it was, and the first thing they would say to me or ask me is, I want to avoid probate, don't I? How many here have heard or said, I want to avoid probate? Yeah, see, none of you knew what we did, but you all didn't want to come there. So, but I get it, because that's what everybody thinks. I want to avoid probate. Why? Why do you want to avoid probate? Just shout out some reasons for me. Higher taxes. Did I hear time? Time. Did I hear cost, too? Did I hear attorney fees? Yeah, those are the big 3, I would say, the big 3 things that we always hear. So when it comes to taxes, that's one of the biggest misconceptions, so we'll talk about that first. In Ohio, we no longer have a death tax in Ohio. We used to. It was $333,333, something around, right around there, where if you passed away with more money than that, you paid a state-level estate tax. We did away with that back in 2013. We no longer have that. There is still a federal estate tax. Right now, you can pass $13.99 million tax-free in the United States. So if you have more than $13.99 million, remember my name is Steve Elliott. Just think of me then. But no, that's what you can pass tax-free on the federal side. So taxes we don't really have to worry about when it comes to probate. Anything you own at death does count towards that number. of 13.99, whether it's probate or not. And we'll talk about that a little more. Time. An estate should take anywhere from 6 to 9 months, give or take. We have estates that finish, really small estates. We call it a release from administration. It's like an abbreviated estate. Those can take a week or two, so it can happen quickly, or it can take several years. The longest estate I dealt with in practice was 5 years long. I had a brother and sister, their mom passed away, and they fought about everything. Everything. It finally got to the end. The estate was worth a couple $1 million, so there was some money there. It got to the end, and the only remaining assets that hadn't been distributed was like a hope chest and some Afghans, and they were still fighting over those. So a lot of times it depends upon what the property is and who the people are involved as to how long that estate can take. If everybody's agreeable and the assets aren't too complicated, I'd say 6 to 9 months, somewhere in there. Attorney's fees. Everybody's always worried about paying the attorney, right? Any estate that we have, if there's an attorney fee, so if you hire an attorney to help with an estate, they get paid out of the estate assets, so you don't have to front that money to them. They get paid at the end out of those estate assets. And we look at every attorney fee application before it gets paid. So we make sure that that attorney billed a reasonable bill based on what they did, that their hourly rate was reasonable and all of those things. So we do review those when they come in to try to help safeguard against somebody getting, overbilled, unless everybody in the estate consents to it. So if there's 4 beneficiaries and 4 beneficiaries say, hey, I hired Steve Elliott, he did a great job, I'm okay with him getting paid this, and they sign something, then we don't review it. But if there's not approvals from everybody, we take a look at it and make sure that it is reasonable. So we talked about those 3 things right off the bat. So when those clients would come into me and they'd say, I want to avoid probate, don't I? I would give them my typical lawyer response. We learned this in law school. I would go, it depends. Do you want to avoid probate? I need more information. What do you own? Who do you owe? What are you trying to pass? Who are you trying to pass it to? Do you have kids? Are you divorced and remarried? Do they have kids? There's a lot of different factors that go in whether you want to avoid probate or not. So when it does come to probate, we kind of talked about the time and things that take, and that's why people want to avoid it mostly. That's 6 to 9 months, you'll hear the phrase, it was tied up in probate. That means it hasn't been transferred to the beneficiaries yet. That's what everybody wants to avoid. And if something has to go through probate, that's what happens. It's tied up in probate until it gets distributed. And your will is what tells us who gets what. So I know you guys all just met me, but I'm going to ask you some personal questions today. Who here has a will? All right, good. If you're going to write something down that I say today, have a will, have a will, have a will. In that will, you tell us who gets your stuff. If you're like me, I have 3 kids. Everything says when I die, my will says it goes to my wife. And if she's not alive, it goes to my 3 kids, equally between my 3 kids. So if that's how you feel and that's what you put in your will, anything that passes through probate, we make sure that that's where it goes, to whoever you name. So if you say I have 3 kids, but I want it divided in 4, I share to each of my kids, and 1 to my church. You can do that, and we make sure that that's how your estate's divided. So that will tells us who you wanted your stuff to go to, so make sure you have that will. If you don't have a will, who gets your stuff? The state, eventually, but it's a long time before they would get it. So there's a statute out there that says who gets it. I don't spend a lot of time on this, but I'll hit it real quick. If you're married and don't have kids, everything goes to your spouse. If you're married and you have kids and all of those kids are with the person that you were married to when you died, everything still goes to your spouse. If you're married and you have kids from a prior relationship, your spouse gets some and your kids get some. If you're not married and you don't have kids but you have grandkids, it goes to them. If you don't have grandkids, then it goes to your parents. If your parents aren't alive, then it goes to your siblings. If your siblings aren't alive, then it goes to your grandparents. And if your grandparents aren't alive, it goes to their siblings, all the way down to like 4th cousin twice removed. Thank you. Who here knows who their 4th cousin twice removed is? Nobody. We literally have estates that it gets to that, where you have to hire an heir search firm to figure out who the family members are. So avoid that. If you have a will, your will controls. So make sure you have that will. In that will, you can also mention, if you have minor kids, who could be guardian of your kids to raise them into adulthood if you pass away before they're adults, or if you have custody of grandkids or nieces or nephews, whatever. you can say who you would want to be guardian for those kids, and you pick who's in charge of your estate or who the executor is as well. We want you to pick all of those things. We don't want anybody else having a say in that. Yes? Did you look at my notes? No, because that's what I'm going to talk about next. Great question. So what I was talking about with the will, that's for everything that doesn't transfer automatically when you die. What are things that transfer automatically? Transfer on death accounts, payable on death accounts, accounts that you have beneficiaries designated on. Anything that you can name a beneficiary to get, that asset passes to whoever you have named on that account, regardless of what your will says. So if you're going to write a second thing down, if you have TOD or POD accounts, does anybody have those? They can be bank accounts, checking accounts, savings accounts, CDs, 401ks, 403bs, IRAs, mutual funds, stock accounts that you can name a beneficiary on, life insurance policies. Anything you can name a beneficiary on transfers on death, and whoever you have named as the beneficiary gets that asset regardless of what your will says. So when I was working at the CIA, for example, I had a life insurance policy there. I wasn't married yet, and I had my mom designated as the beneficiary. If I still had that life insurance account, when I died, my will says everything goes to my wife, and if she's not allowed, to my 3 kids. That life insurance policy has my mom listed on it. My mom gets that money. Doesn't matter what my will says. So if you have TOD, POD, beneficiary designations, check with those companies as to who you have designated as those beneficiaries. Make sure that's who you want on there. And we'll talk about that in further detail here in a minute as well. But remember, those beneficiaries trump what's in your will. So make sure that those are who you think they are. Several months ago, I had a guy, we had a hearing on something unrelated, and we were just kind of talking afterwards. And he said that he had a bank account, his wife had passed away, and after his wife passed away, he changed the beneficiaries on the account to his kids. And he said, I have 3 kids, and I named all 3 of my kids on that account. He said, I went back several weeks later to check on it, and they said, yep, we have your beneficiaries designated. Here they are, and it was only 2 of his kids. Even though he put 3, the bank made a mistake and listed 2. So make sure, ask the bank, ask the investment company, ask the life insurance company who is designated as those beneficiaries on those accounts, and make sure it matches up with who you think is on there. That's a very important thing. And again, those things pass outside of probate. So what does that mean? I have beneficiaries designated on all of my accounts, transfer on death, my IRAs, life insurance, everything. So if I'm walking out of here today and I get hit by a Coke truck and die, my wife can go to the bank with my death certificate. Once she gets the death certificate, that's the one document she has to wait for. She goes to the bank with my death certificate, fills out a form. Steve died. I'm the beneficiary on this account. Shows them the death certificate, and the money transfers like that. They give her a check. They open an account in her name, whatever the case may be. Life insurance, same thing. Here's a death certificate. I'm the beneficiary. Check gets cut like that. Might take a week, but it happens quickly. That's one of the biggest things I think that's attractive about those TOD and POD accounts is it happens quickly. It keeps it out of probate, and it transfers to those beneficiaries quick. So make sure you have beneficiaries designated. If you don't, that account has to come through probate. So if you have a beneficiary named on there and they pass away, for example, it's like not having anybody named, and then it has to come through probate, and then your will dictates who gets it. So just make sure, again, who you have named is who you want it to go to. You can also have transfer on death or payable on death for your, or transfer on death title for your car. Does anybody have a TOD title for your car? I'm starting to see more and more hands. That's a newer concept, but if you go to the title bureau, you can have them issue a new title as transfer on death where you name a beneficiary to get that car if you die. You have to own the car. If you owe the bank, you don't have the title yet, so you can't do a TOD title, just an FYI. So if the car's paid off and you have the title, you can do a TOD title. Operates the same way. Get hit by that Coke truck, my wife goes into the title bureau with my death certificate. They give her a new title, car's in her name. In Ohio, just as an FYI, in Ohio, if you pass away and you're married, your spouse has the right to receive any automobile that you own in your own name up to $60,000. So if you have two cars that are less than $60,000 in value, it kind of transfers that way as well, just as an FYI. People always ask me that, so I thought I would add that. You can also have transfer on death for your real estate or your house. Does anybody here have a transfer on death affidavit for your house? What about a survivorship deed? Does anybody have a survivorship deed? Okay. Talk about survivorship real quick. I have a survivorship deed for my house. I use myself as an example all the time. Steve and Ann Elliott own the house, and you'll see on your deed, if you're not sure if you have a transfer on death deed, it'll say, for their joint lives remainder to the survivor of them, or something along those lines. So take a look at your deed. If it has that language in there, that means if I die, my wife again takes that death certificate to the recorder's office, fills out an affidavit. Steve is my husband, he's died, here's his death certificate. You sign it, it acts like a deed and transfers the house 100% into her name. So that's if you have more than one name on your deed with that survivorship. Yes? It depends. If you have owned your house since prior to the 90s, you definitely want to check your deed because it might not be survivorship. After then, it's most commonly survivorship, but not 100%. The title company probably asked you when you bought it if you wanted a survivorship deed, but you definitely have to take a look at that deed and make sure. Yeah, because there are still deeds now that you can be joint owners without survivorship. Again, if you're married, most title companies by default do it in survivorship, but not necessarily, so you definitely want to check on that. Great question. So the question was, she has an irrevocable trust, and she was asking if a survivorship deed would have been better than the irrevocable trust, right? It depends. I'm going to keep saying that today. When you transferred it into that irrevocable trust, it took it out of your name personally, and then the trust dictates who gets it. So whatever the trust says is who would get it. And really, there's not one that's better than the other. An irrevocable trust would shield it from Medicaid recovery. And before I get 100 questions on that, I'm not going to talk about that much today. That's a whole nother presentation. But yeah, so if it's in an irrevocable trust, the trust says who gets it. Yeah, or even if it's not irrevocable, the trust would dictate who would get it. Now, that's assuming that you did transfer the property into the trust. So yes, if the trust is listed as the owner on the deed, then it's in the trust. Yeah. I saw another hand.
We live in mobile home. I have a title. If something happens to me, it automatically goes to her. That title be her.
If it's a transfer on death title, so you would have to look at the title and see, are you both on the title? If you're both on the title, then yes. Good question. If there's two names on the title, it would transfer to the survivor, so it doesn't have to be a transfer on death title. Good question. So we were talking about survivorship deeds. Now we have transfer on death affidavits as well. So a transfer on death affidavit is just kind of like a survivorship deed, except you're not a joint owner. So I own my house jointly with my wife. We have a transfer on death affidavit in place that says if both of us die, or when the survivor of us dies, we want the house to be transferred to our 3 kids. So we have that transfer on death affidavit there so that when something happens to both of us, it transfers to our 3 kids automatically. And it happens the same way, just like the survivorship deed. Kids take in the deed, sign an affidavit saying, my dad died, I'm the transfer on death affidavit beneficiary, the house is now mine. They record the deed and the house transfers to them quickly. Does everybody here live in Summit County? No? Portage? Stark? Man, you guys are from everywhere. I should have asked that first. All right. So if you do live in Summit County, I don't know if you know, you got your property reappraised a couple years ago, so now we're all millionaires because we own real estate here in Summit County. So if you have that transfer on death affidavit, we're taking our biggest asset, a lot of us, our biggest asset is our house. We're taking our biggest asset, we're leaving it to our beneficiaries in this transfer on death affidavit. It's out of probate. They don't have to wait that time. It's not going to be tied up. They can do with it what they want at that point. That's a great idea, right? It depends. I leave my real estate to my 3 kids. My oldest son wants to sell the house. My daughter wants to rent the house out to make money. And my youngest son wants to live in the house. What happens? They end up in court fighting over what should happen with the house. So if you want to do a transfer on death affidavit, it is a great thing. It transfers your biggest asset quickly, keeps it out of probate. What I want you to ask yourself is, what am I trying to transfer? Do I want them to have the house, or do I want them to have the benefit of the house? In other words, do I want them to sell it and get the cash? 99% of the time, the 3 kids agree on what they're going to do. Most of the time, they sell the house and split the money anyway. Or if one of the siblings wants to buy out the other ones, they can always do that as well. But think about that before you just transfer it to them. Are they going to agree? And I would bring that up to clients all the time, and they would say, oh, we don't have to worry about that. My kids never fight. And that's what I did. I chuckled when they said that. And now for the last 7 years, I see kids that have never fought before that fight over things in probate. So just keep that in mind. Are there any issues that may arise if you're going to leave that property to 3 people? You have 3 cooks in the kitchen. The recipe can get messed up, right? Let me add another layer to that. Let's say your 3 kids are married. In Ohio, you cannot transfer real estate out of your name if you're married unless your spouse signs off on the deed too. They don't own it, but they own what's called a dower right. Real estate, if you're married and you're transferring it, spouse has to sign. So now instead of having 3 cooks in the kitchen, you have 6. Because your kids are married, their spouses have to agree and sign off on the deed once your kids own it to sell it to somebody else. And inevitably, you would have that one in-law or outlaw, depending on what you call them, whispering in your son's ear, hey, you took care of your mom and dad. You should get more than your brother and sister. Now you have a whole nother fight on your hands. So think about that. What is it you're trying to transfer? And could there be potential issues? God willing, it's not like this. If you have a child who has a drug issue or issues with creditors or, maybe a mental health issue, do you want to just hand them that house or that portion of the house? So just things to think about. Again, 98% of the time goes to the 3 of them. They work it out, no big deal. But those are just things I'd like you to think about before you just name beneficiaries like that. Just think about what it is. Are there going to be any issues that could arise from that? I saw a hand. Good question. She said to have the transfer on death affidavit, will we do that through the recorder's office? Yes, the Summit County Fiscal Office, if you live in Summit County. The Portage County, I think there are auditors out there, the Portage County Auditor's Office. And Stark County, I think, is a recorder's office. But whoever does the deeds in your county is who you would go to. I know in Summit County Fiscal Office, they have those forms on their website, or they'll provide them to you if you go down there. If you are going to Summit County Fiscal Office, check and see where they are. Their building is being remodeled right now, so they're not downtown, they're in a different location, so just double check that. So right now they're temporarily relocated, so if you're interested in getting those forms, you can get them there. Yes?
Is this across the boards, across all states? So the same rules here in Ohio would be in California?
No.
You know what I'm saying?
Yeah, great question. What I'm talking about is just Ohio. Different states have different laws depending on what it is. They may call them something differently, or they might just have a completely different set of rules that says you can't do TOD. It depends upon the state. Good question. Yeah. Mm-hmm. So the question was, if you have multiple pieces of real estate, it's good to have it in a trust, because if it's in a trust, then Medicaid can't basically take the property. Is that a good summary? I'm not going to talk a lot about Medicaid. Again, to avoid Medicaid estate recovery. So in other words, if you have to end up going into a nursing home, I don't know if anybody has had to deal with a nursing home, it's about $10,000 to $12,000 a month if you have full nursing home care. That's a lot of money, obviously. At some point, most people run out of money, and then they have to qualify for Medicaid. So if Medicaid starts paying for your stay in a nursing home, they have the right to be repaid from your estate, including your real estate. So if you're on Medicaid, bless you, if you're on Medicaid for a year, $120,000 bill from Medicaid, Medicaid files a claim against your estate to get that $120,000 back. You can avoid that by putting all of your property in an irrevocable trust, bless you. Put all of your property in an irrevocable trust and then not need Medicaid for 5 years. Hold on for 1 second. When you transfer it into that trust, you lose control over it. You're not in charge of it anymore. You have to name a trustee that makes all decisions about your property. Also, if you're thinking about doing that, I would highly encourage you to go visit a Medicaid-only nursing home before you make that decision. People always say, well, I want to leave my kids money. I get it. All of us kind of want to leave something for our loved ones, when we pass away. Do me a favor, go to a Medicaid-only nursing home and visit it and see if that's where you want to spend your remaining days. I'm not trying to badmouth nursing homes when I say that, but there can be a difference between Medicaid nursing home and a private pay nursing home. So if that's your goal, that's just a piece of advice from me. Don't tell the nursing homes I said that. There was a question, right? The look back period or look back window, yeah. It's 5, yeah. Unless it recently changed. If it changed within the last couple of weeks, yeah, I think it's still 5. Yeah. It has to be, yep, the moment you apply, they look back from that period. Yeah. Talked earlier that you want to make sure you know who your beneficiaries are on those accounts. Let me tell you a personal story on how that can have an impact. My dad, I'm from Canton originally, Stark County. My dad worked at Timken. When he retired from Timken, he bought an 84-acre farm in Magnolia, Ohio, just south of Timken, and that's where he was going to, live out his years. Unfortunately, he was diagnosed with brain cancer, and what normally happens when someone gets a diagnosis like that, my dad went and had his estate planning done at that point. So he owned the farm, and in his will, he said, I want my farm divided equally, half to my kids and half to my wife. Like a lot of people in America nowadays, I would come from a blended family. My parents were divorced. My dad was remarried. I have a stepmom. And in his will, he said, me and my 3 sisters get half of the farm, and my stepmom gets the other half. What my dad didn't know and what his attorney didn't check was he had a survivorship deed for that farm. So my dad and my stepmom were listed on that survivorship deed together. So when my dad died, it automatically transferred to my stepmom. And even though my dad's will said 50% to my kids, 50% to my wife, it all went to my stepmom. So what the will said didn't matter because of that survivorship deed. Same thing with that transfer on death affidavit. So make sure you know what's there so that your goals can be carried out. The good thing for me, I'm still close to my stepmom. I just talked to her a couple weeks ago. We still get together for dinner and everything, so we're still close. So I think it'll turn out okay for me and my family because we still have that relationship. It's not guaranteed, but I know we are in her will, and you know how I know? Because I drafted it. But she could change it. And if she wanted to, I'd be fine with that too. It's hers. But just an example to show you that you definitely want to make sure that those things are there. So we talked about probate. We talked about wills, what your will does, how you definitely want to have a will, what transfer on death does, what you can do in transfer on death. Do you want to avoid probate? It depends. Now we're going to talk about some of the things that we gave you today. You guys thought this was a free presentation. It's not, because I gave you all homework that you have to do. We were going to meet back here next week, and I'm checking everyone's form. No, I'm just kidding. This form, we were very creative when we named it. We call it our yellow sheet. I call it a treasure map. You can call it whatever you want, a personal records and important documents - yellow sheet. That's what it says on the front. Why do we make it yellow? We made it yellow so that when you pass away, you can say to your executor, hey, when I pass away, go to my lockbox and pull out the yellow sheet. If you take a look at this document, it has you list, are you married? Where's your marriage license? Were you in the military? Where's your DD-214? Where's the deeds to your house? Where's your car titles? It tells us where all of those important documents are. If you look on the inside, it also has your name, like your kids and things like that. If you have an executor that's not a family member, very important. On the inside, it has like accounts that you can list. Like, what bank accounts do you have? What investment companies do you go to? Who do you have investments with? Do you have a safe deposit box? You list all of those things with account numbers because, again, remember, you're not there and your executor starting from scratch. This gives them the treasure map as to where your things are. So you list all those things, what you own, who you owe, so that your executor can find them. Obviously, when this thing is filled out, has all of your private information on there, you want to hand out copies to everybody, right? No. Listen to the other Elliott. That's what I'm going to call him. Tell him I said that. Listen to the other Elliott and don't give out that information. Get information, right? Don't give out this information. Keep it in a safe place. I recommend you keep it in a safe, fireproof safe or lockbox in your house. One fireproof in case your house catches on fire. If you don't have that, keep it with your other important documents in a safe place wherever you keep them. Make sure you tell who's going to be in charge where the documents are. You know, look for the fireproof safe in the basement. That's where I recommend you keep it. Fireproof safe in the basement. Your house catches on fire, fire burns up, water falls down. It'll be safer in the basement than it would upstairs or in the attic, for example. If you don't have that, put it in a Ziploc bag and put it in your freezer. If your house catches on fire, your freezer usually survives. If you're going to do that, make sure you put it in a Ziploc bag first. I've done this presentation I don't know how many times, and Judge Stormer did it before I started doing it for the court. So we've probably told every criminal in Summit County that this is going to be hidden in your freezer. So keep it in a fireproof safe if you have it. Judge Stormer would always say, don't put it in your underwear drawer. If a criminal breaks into your house, the first place they look is your underwear drawer because apparently people keep valuables there. I don't, but apparently some people do. Who keeps no, I'm just kidding. So make sure you fill this thing out. Example of why you want to have this. I mentioned I'm a lawyer, as a practicing lawyer, so that means that I'm named executor in every will of my family. So when I went to the probate court, I didn't have this in practice. I wish I would have, because I would have had all of my clients have this. But when I started working at the probate court and discovered this thing, I took one home and sat down with my mom and said, Mom, I'm the executor, let's fill this thing out. I don't know where she banks. I don't know what investment she has. We don't talk about that. Most families don't. I didn't know any of that stuff. So we sat down, we started filling it out, and she goes, oh, life insurance. I had that life insurance policy that I bought to pay for my burial. And I said, oh, great. What company did you buy it from? She goes, oh, I don't remember. And I said, well, who was the insurance agent? Oh, man, I can't remember his name. Well, where's the policy? Well, it's either in the office or it's under the bed. And I said, well, let's find it. Luckily, we found it. My mom paid for a life insurance policy to help pay for her burial. That's $10,000 to pay for her burial if something happens to her. If I hadn't sat down and filled this thing out with her, would I have found it? I don't know. Or what if her house caught on fire and that insurance policy burned up? Would I have found it? Probably not. So that, sitting down with her and doing this, saved that $10,000 that she worked hard for to make sure that her burial was paid for. So you definitely want to have this filled out so that, we know where your stuff is. Who here does electronic or online banking, bill pay, investing, any of those things? On the back is a place for you to list those accounts with passwords. I encourage you to write down the password to your computer. If everything comes to you electronically and your executor can't get into your computer, how are they going to find out where your stuff is? They might not unless you have this written down. I know updating passwords is painful. It's one of my least favorite things in life is the fact that I have to change passwords every 3 months. It makes me crazy. But this is an important thing if you do everything online. Quick story about that as well. When I was in practice, guy called me up and said, hey, my sister passed away. She didn't have kids, wasn't married. I'm the executor in her will. Can I meet? And I said, yep. And what I did back then, this is probably around 2010 or 2011, somewhere in there. I said, go to her house, collect all of her mail for about 4 weeks. We'll meet on this date 4 to 6 weeks from now. Bring all of that mail with you. And it used to be people would show up in my office with like a banker's box full of stuff. He walked in and he had one envelope. And I said, well, didn't you get your sister's mail? He goes, I did. She does everything online. And I go, do you know how to get into her computer? And he said, no. We had no idea what bank she used, what investments she had, if she had life insurance. We didn't know anything about her finances because they never talked about it. So I had to write letters to all the banks and investment companies throughout Summit County trying to track her stuff down. Did we find everything? I have no idea. There could still be stuff out there, and that was 15 years ago, that she owned that we never found. So again, think about that. You're not there. Who knows where your stuff is? A lot of us, nobody. I mean, my kids don't know where my wife and I have our things. So we better have this filled out so they can find it. Very important document. Did I see a hand? The question was, do you recommend that an executor be a non-beneficiary, or does it matter? What's my answer going to be? It depends. First and foremost, the person you name executor is somebody you trust to do what it is you have set out in the document. You can have two. I don't always recommend that because if you have two and they both have a different idea as to what they're supposed to do, if your will doesn't spell it out, then they end up arguing about it in front of me. But if you're comfortable with two, yes, name two. When I would ask people, who do you want to be your executor? A large majority of the time, they would go, oh, my oldest son. Oh, my oldest daughter. For some reason, they think the oldest is who should do it. That isn't always the case. And I would follow up with, okay, well, what do your kids do? Well, and I'm not trying to disparage anybody when I say this. Well, my son, he works for the road department. He's my oldest, and my daughter is an investment advisor. I would say, well, how about we use the person with the specialized knowledge, the investment advisor, to be in charge of the finances of your estate? And then they would go, oh, I never thought about that. So just think about, one, you have to trust them, and two, do they have some kind of specialized knowledge that makes you maybe want to appoint them? Also think about this, because I always get this question. I know someone was going to raise their hand and ask this. Can I name somebody out of state as my executor? Yes, you can. However, if an out-of-state person is named executor in your will, they either have to post a bond or have someone be co-executor with them. It's in a statute. You can't waive that in your will. So if you name someone out of state, they have to have someone with them or post a bond and hire a lawyer. So you can do it. It's not prohibited. If you say, well, my son Steve would be good at it and my daughter Tara would be good at it, Tara lives in Pennsylvania, Steve lives in Ohio, I would say appoint Steve if you're comfortable with Steve and have Tara as the backup, for example.
Trust. She's in Pennsylvania, I'm in Ohio. Does that mean I have to be bonded or get a bond?
I don't know what Pennsylvania law is, so it depends upon what Pennsylvania law says. If you're trustee, that's different than executor. So a trustee is a person in charge of the assets of a trust. Executor is a person in charge of the estate. And you might be both. Oftentimes you're both. Yeah. So it really, in Pennsylvania law, would have to dictate. Yeah.
I have no family. Can a lawyer be an executor of my will?
Yes, you can name anybody executor. So you can be married, have kids, grandkids, nieces and nephews, and name your friend Steve to be your executor. Again, whoever it is that you trust. And someone asked the question, is it good to have a non-beneficiary executor? It's not a bad thing because that would be then the person in charge of making sure that the money goes how it's supposed to be and they don't have a vested interest in that property. At the same time, they are entitled to charge executors' fees. Just keep that in mind. Oftentimes, this is a family member, they waive it. But if it's somebody independent, then usually they want to be paid. So it can be anybody as long as you trust who it is. And lawyers will do it. I'm not permitted to give you legal advice. However, I'll say this, even though I'm sitting up here for an hour giving you legal advice, right? If you name an attorney as your executor, they are entitled to be paid as an executor and as an attorney. Some people think that's double dipping, but it's what the statutes say, so they are entitled to be paid for both roles. I saw another hand, yep.
If you have TOD on, say, property, and you have some of it in a trust, and you have a will written out, what takes precedence?
It depends. Whatever's named or whatever is in the will goes pursuant to the will. Whatever you have as TOD goes pursuant to the TOD. And if there's anything left over, the will would control. Generally speaking, yeah. Let's talk after a little bit. Okay. Remember, TOD trumps everything. So if it's in TOD, that's what would happen. You can't really, yeah, we'll leave it at that. And then maybe we'll talk after a little more. Filed in Arizona? So it was drafted in Arizona? Does he own anything in Arizona anymore? If I was still a lawyer, I would hand you my card right now. No. So is probably not. If everything is in the trust and gets distributed out of the trust, you would probably just need an attorney where he passed away, because that trust will follow him to Virginia. So even though it's an Arizona trust, everything in the trust, if everything's in that trust and it's administered through that trust, you probably just need an attorney in Arizona, or I'm sorry, in Virginia. Yeah. Any other questions? So if a parent passes away and they owe credit cards, there's credit card debt, is it wiped away? Or does it, what was it? Or do you have to pay it? It depends. So creditors have 6 months from the date of death to file a claim in the probate court saying they want to be paid. So if your parent passes away, that creditor has 6 months to file a claim in the estate. They have to serve that claim on an executor. So there has to be an estate open, an executor appointed, and then they have to give that executor the claim. Credit card companies do it all the time. Steve passed away, he owed 10 grand to Chase. They would wait till my wife was appointed executor, and then they would file their claim, and then at that point they're entitled to be paid out of the proceeds of my estate. If they don't file a claim, they don't have to be paid. So just because I die, my wife doesn't have to pay my credit card bill. My estate has to pay it first. So if there is an estate and they file that claim, then the money has to be paid out of the estate to that creditor. So if they don't file a claim, then again, that debt could be wiped out. If you have somebody who has a large debt when they pass away, I recommend you talk to an attorney to come up with a plan on how to handle that. Because some people just wait 6 months and then file the estate after that. So the 6 month claim period has passed, and the creditor didn't file a claim in time because there wasn't an estate open, so their debt goes away. But some creditors will open the estate. Just because I'm named executor in your will doesn't mean I have to open your estate. A creditor can. So if you owed those credit card companies, Chase could hire an attorney to open your estate in Summit County, serve that claim on the attorney to preserve their claim. And then when I show up with the will and say, hey, I'm here to probate her estate, they would say there's already been a claim filed, blah, blah, blah. So they have a way to protect themselves, and they often do. Nursing homes will do that a lot. Medical providers will do that a lot if there's high bills for those things where they'll come in. We call it forcing open an estate, where they can file and open your estate. Another important reason to have a will, right? Who do we appoint as the executor? Who you name. If you don't name someone, who can we appoint? Anybody. Anybody can apply to be your executor. So name them in a will so that, again, we're not the ones making that decision. Family has precedence over non-family members, but just keep that in mind. Have that will so you have somebody named. All right, so we talked about estates. We talked about TODs. We talked about our yellow sheets. We have extra copies of these. If you have a loved one, family member, spouse, kids that you want to take these to, we have extra yellow sheets. You can also find them on our website. They're PDF fillable, so you can fill them in and print them out. If you print them out on white paper, don't tell your executor to find the yellow sheet. So we also have copies at the courthouse. If you live in Summit County, you can swing down. We'll give you copies there as well. So just keep that in mind. We have extras to hand out. First copy's free, second is $10. So we've talked about whether you want to avoid probate. The answer is it depends. Let me tell you a situation where you always want to avoid probate if you can, and that's when it comes to guardianships. Has anybody had to deal with a guardianship for a loved one before? They can be a pretty tough situation. A guardianship is someone is no longer mentally capable of making decisions about themselves or their finances, and they need a decision maker in place. Something's filed in the probate court, application for guardianship. You have to have a doctor that fills out a statement that says Steve's incompetent and can't handle his finances anymore because he has Alzheimer's, for example. That case is opened in our court. We have a hearing, and then we would deem that person incompetent and appoint a guardian for them to make decisions for them. We have 2,600 open guardianship cases right now, give or take. So that's 2,600 people that can't make decisions for themselves, and someone has been appointed for them. We want to avoid that. It can be a very tough situation. For example, if I filed for guardianship of my mom, I file all that paperwork, file it in the probate court. If somebody files for guardianship against you or on you, our court investigator comes out and serves you with notice of it. So you hear like in California where someone's appointed guardian, the person didn't even know they had a guardian and they steal all their money. Doesn't happen in Ohio. Court investigator from the probate court is required to come out and serve you with notice of that filing. So the court investigator goes out, talks to my mom and says, hey, Steve filed for guardianship over you. Do you agree with that? She says, no, I don't need a guardian. Now we have to have a full-blown hearing in probate court, and I have to take the stand and testify as to why my mom needs a guardian. She's been diagnosed with Alzheimer's. She leaves the stove on. She's incontinent. She gets lost in her car. Things that are embarrassing, that we don't want to say about our loved ones. But that's what we have to do in a guardianship proceeding, prove that they need a guardian. How do we avoid that? One of the documents we handed out is a healthcare power of attorney. Who here has a healthcare power of attorney? Good, I love to see all those hands. If you don't have one after today, you have no excuse, because we just gave you one that you can fill out. This is a document where you can designate somebody to make healthcare decisions for you if you are not able to. If you're going to use this document, it's fine throughout the state of Ohio. You can sign this, fill it out, and sign it today, and it's valid. It has to be witnessed by 2 people or notarized. The 2 people that you have witness should not be the person you're picking to make your decisions for you. It has to be someone not named in the document, okay? So if you fill this out, have 2 witnesses, great place to do it, because there's probably people here you're not related to that you're not gonna name. They can be your witnesses. So you name someone to make healthcare decisions for you if you're not able to. Walking out of here today, I get hit by that Coke truck. I keep saying that. I'm going to watch my back when I leave here today. I get hit by that Coke truck. Ambulance takes me to the hospital. I'm laying there unconscious. I need brain surgery because of an injury. I can't make that decision because I'm unconscious. My wife can walk in with my healthcare power of attorney and say, give Steve that brain surgery. I'm the person that he designated to make those decisions for me. I get hit by that because I'm not able to make that decision, right? I get hit by that Coke truck. Ambulance takes me to the hospital. I'm in the hospital. I'm laying there. I'm in a lot of pain. And I say to the doctors, give me pain meds. I'm in a lot of pain. My wife can't walk in with the healthcare power of attorney and say, stop the pain meds, make him suffer. I'm awake. I'm able to make the decision for myself. I make it until I can't anymore. And then my wife takes over. I saw a hand. Sorry to hear that. So she has a healthcare power of attorney now? Yeah, so in order to sign a healthcare power of attorney, you can't have been deemed incompetent already. So you have to have the capacity to sign this document. What does that mean? You have to understand what it is that you're signing. You have to do it voluntarily and basically know who it is that you're appointing. So you have to be able to understand kind of those basic things, just like signing a contract. So if something happens has happened that you can't do that now, you really can't execute a healthcare power of attorney. That said, even somebody with Alzheimer's, you have what's called a lucid interval. If you've ever spoken with somebody who has Alzheimer's and one day you speak to them and their memory is good, they remember everything, and they know who they are, who their kids are, what they own. If they're having a lucid interval, they can execute one of these documents. If they're not, then they can't. So you would have to get guardianship for her, and you cannot do a healthcare power of attorney, unfortunately. So once you're guardian, you cannot execute a healthcare power of attorney for that person because the guardian is the person appointed to make the decisions. Once you're appointed guardian, then you can make healthcare decisions for her. So you couldn't use a healthcare power of attorney for that. Yes. Yes. So if you don't have a healthcare power of attorney, the guardianship acts basically as the decision maker. Good question. I wasn't clear on that. So yes, if someone's appointed guardian, they are the decision maker. So if you don't have that healthcare power of attorney or somebody named, the guardian is the one then who would make all of those healthcare decisions for you. That's called guardian of the person. I see another. What I did with mine and what I would tell clients is always keep your original. Keep your original. Give whoever your decision maker is a copy. That way, if something happens to you and they need to go to the hospital and make decisions for you, they have a copy. Doctors will accept a copy of these documents. They don't have to have the original. If you've signed one, you can also give a copy to your doctor for them to put into your health records. A good thing to do. So that they have them on file. If you ever have to go into the hospital for a procedure, they will ask you, do you have a healthcare power of attorney and a living will? We're going to talk about living wills next. Do you have a healthcare power of attorney? If you say no, sometimes they'll give you the form and have you fill it out right there. Just keep in mind, if you fill out a new one and you have one, your new one is the controlling one. So if in your original you named Steve, you got to the hospital and you filled out a healthcare power of attorney and you named Tara, Tara is now your healthcare power of attorney. Your newest one is the one that dictates who it is. I saw another hand.
Is there a difference between a healthcare power of attorney and like a financial power of attorney?
Yes, and we're going to talk about that too. Yeah, you guys are a great crowd. Keep stealing my thunder, but you're a great crowd. So the next document I'll talk about is another one that we gave you. It's called a living will. Who here has a living will already? Good number of hands again. Living will is a document that you sign now that says, if I'm in a terminal condition with no chance of recovery and or a permanently unconscious state. Permanently unconscious state means brain dead, not a coma, brain dead. You have a total loss of brain function, can't feel pain, unaware of yourself and your surroundings, brain dead, terminal condition with no chance of recovery. And this document says, don't take extraordinary measures to keep me alive, allow me to pass away naturally. No ventilator, no tube feedings or hydration and nutrition. In this document, you can choose what you would want to receive. If you say, like I think Walt Disney's like cryogenically frozen, and he says, if you come up with a cure for the disease I had, thaw me out and bring me back to life, that's fine. That's his personal decision. And if that's how you feel, that's fine. But if that's how you feel, don't fill out a living will. Because this living will says, don't take extraordinary measures to keep me alive. Allow me to pass away naturally. Your health care power of attorney can make that decision for you. There's a box on there you can initial that gives them the power to do that. But if you feel like, don't keep me alive artificially, don't put me on a respirator, don't give me the tube feedings, fill out that living will because it's you telling us, hey, I don't want this. I mentioned earlier my dad passed away from cancer. He had a brain tumor, and when it was close to the end of his life, he had a terminal condition. The doctor said there was no chance of recovery. Death was likely to occur soon. None of the treatments worked. That came up, and I handed them my dad's living will because my dad said, don't keep me alive artificially in this situation. Allow me to pass away. And I'll be honest with you, it was a huge relief. I didn't have to make that decision as his healthcare power of attorney because he did it already. So if that's how you feel, take that off your loved one's plates and have them, and you fill out this living will telling everybody that that's what you would want. Again, one, we make sure that your wishes are carried out. Two, it takes the burden off of them, so that you're not kept alive artificially if that's not what you want. Does anybody know the name Terry Schiavo? If you remember her, the lady in Florida, I think it was back in the 90s, late 90s somewhere. She was in her late 20s, had a cardiac event, lack of oxygen to her brain. She ended up brain dead. In Florida, they call it a permanent vegetative state. So she was brain dead. Her husband said she would not have wanted to been kept alive artificially. Her parents said, no, she's a fighter. She would have wanted to be kept alive, keep her alive. They ended up fighting it out in court to figure out who was right. It took like 13 years. It went through all the state courts. It went to the federal courts. Congress was dealing with it at one point. They were calling it a right to die. I think the president got involved, President Bush. I mean, it was a nightmare, and it went up and down through the courts. And finally, that dozen years later, they ended up saying, we're going to withdraw the life support, and then she passed away. Assuming her husband was telling the truth and she wouldn't have wanted to been kept alive artificially, she laid there for 13 years needlessly while her family fought it out. So again, if that's how you feel, fill out that living will, because that lets the world know what you would want to have happen. The other document that we'll talk about, somebody asked about a financial power of attorney. We don't hand those out, but that is a document that you would want to have too. You'll hear it called durable power of attorney, financial power of attorney, business power of attorney. All of those things are kind of the same thing. It's like the healthcare power of attorney, but everything finances. I get hit by that Coke truck. I'm in a coma. I have to go to a facility for care. My wife can use that financial power of attorney to pay my car bill, pay the electric bill, pay the mortgage, pay for my care. She can use the financial power of attorney to do that. If you have a joint account with somebody, they already have access to that account. Just keep that in mind. But that financial power of attorney is there in case you don't have somebody named on that account with you. People would say to me, well, I'm married. My spouse can just do that, can't she? It depends. Maybe, maybe not. And then I would also say this. Well, so you guys are married, so you travel together? Yeah. You get on an airplane at the same time? Yeah. Oh, you drive in a car at the same time? Yeah. Well, what if you're in an automobile accident and both of you are laying there and need a decision maker? These documents, you get to pick backups. Financial power of attorney, you pick backups. If you want a financial power of attorney, call an attorney to have it drafted for you. You can find them online. I don't necessarily recommend that. You can type in Ohio Financial Power of Attorney, and it gives you a document that says Ohio Financial Power of Attorney, and it's from Michigan. And the last thing an Ohio person wants is a Michigan Power of Attorney. IO. That was for my Michigan hat guy over here. Yes. Yes. The question was, is it true that a financial power of attorney is only good until your death and then something else takes over? Yes, powers of attorney die with a person. That's what I would always tell clients. You can have the best powers of attorney in the world, but once you die, the power of attorney dies with you. So the person then that can make decisions for you is your executor. And when I say you, obviously I mean your assets, your estate. Yes. Yes. The question was, he has a financial power of attorney for his wife from Arizona. Is it still good in Ohio? The answer is yes, as long as that document was signed properly pursuant to Arizona law when it was signed. And their law isn't, so for example, in our state, you have to have a notary to sign a deed. So if that Arizona power of attorney has a notary, you should be able to use it as a deed here. Or to sign a deed here, I'm sorry. But yes, different states have to honor other states' living wills, powers of attorney, financial powers of attorney. So if you have one from another state, yes, they will be honored here. However, does anybody here work for a bank? No one? Okay, good, let's talk about them. Legally speaking, they have to honor that Arizona power of attorney. Sometimes, is this going to be broadcast on TV? Never mind. No. Sometimes a bank will look at a power of attorney and say, hey, this is Fifth Third Bank. I don't see Fifth Third Bank in that power of attorney. I'm not going to honor that, or we're not going to honor that power of attorney. It's 100% legally wrong. However, they do that sometimes. And I love banks. But sometimes that does happen. So just keep that in mind. So if you do have a power of attorney from a different state and you plan on staying in Ohio, I would recommend that you get new ones just to take that guessing work out of it. If you're going to sign a financial power of attorney, I also recommend that while you're competent and able to do so, take it to your bank and say, I have a financial power of attorney. Steve is named as my attorney in fact, so he can make financial decisions for me, and have them put a copy on your file. That helps if they know ahead of time that you had done that. And can hopefully take away some of the guessing work. Also, if you're in the hospital and you hand a doctor in Arizona power of attorney for health care, it might take them a little while to look at it and make sure that they're okay with it. If you hand them an Ohio healthcare power of attorney, they've seen 1,000 of them, there's no question about it. So you can, obviously, and they're free. We gave them to you. Again, you can find them on our website, type it in, fill it out, print it out, and you should be good. But if you're from a different state, we'll honor it, but sometimes it's good just to have Ohio documents. You don't have to, but, and obviously if somebody is already, incompetent in needing that document, then you have what you have, and, use that document. Last document I'll talk about, I'm getting close to being out of time here, is the What If I Had Dementia form. The healthcare power of attorney and living will are Ohio forms, good throughout the state of Ohio, honored everywhere. This, I'll say, is a Summit County-centric form. Judge Stormer went to a presentation on Alzheimer's, and they had this form. She thought it was great. I think it's great. So we stole it and we started using it, or borrowed it. This is a document that you fill out that says, if I have Alzheimer's or dementia, here's the level of care that I would want to receive. And it goes through the stages of the illness, mild to moderate to severe. So for example, if I'm able to stay at home with some home health aid, this is the level of care that I would want to have at home. If I'm in a facility, this is what I would want. My grandma was diagnosed with Alzheimer's, passed away from Alzheimer's. What happens oftentimes at the end of that disease is we forget to feed ourselves. We forget how to feed ourselves. In this document, you can say, if I have severe dementia and I forget to feed myself, please don't feed me, and allow me to pass away. You can write that in this document. My grandma passed away 15, 20 years ago, so we didn't have this form. So my mom and my mom's sister were left with making that decision. Should we feed her or not? Again, they had the ability to make it because they had the healthcare power of attorney, but if you have certain things that you don't want to have happen to you, or that you do want to have happen to you, if you have Alzheimer's or dementia, put them in this form. If you live in Portage County or Stark County, you can still fill it out. Will the judge honor it? I can't say 100% that they would, but I'm sure that they would take your wishes into account if there was a hearing on whether, you should receive 2 feedings or whatever if you had dementia, assuming you didn't have a living will. So again, that's a Summit County form, but we hand it out. I just like to mention that, yes. You cannot. Once you are appointed guardian, you have the power to make those decisions for her, so you don't have to fill the forms out. In fact, you can't fill these out for someone else. Unless they're okay mentally and just can't physically fill it out, then you can, at their direction, fill it out. But if someone has been deemed incompetent or to the point where they can't make a decision, then they can't fill it out. So then you would have to make that decision as the guardian.
Can a person from another state, power of attorney from another state like Alabama, says that I don't want to do this anymore, I'll give it over to you, and you live in Ohio. Can you do that?
So if you're named as a power of attorney in someone's document and you no longer want to do it, can you hand it over to somebody else? Yes, you can, as long as that other person is named in the document. So if my mom named me as it's actually called an attorney. In fact, I just say power of attorney to make it easier. If my mom names me as power of attorney and nobody else, so there's no backups, I can't say I resign and I'm going to let my sister do it. I can't pick someone to be my mom's power. My mom can name 2, and if I say I don't want to do it anymore and my sister is named as the backup, then my sister would take over. So my mom can name backups, but I, as the attorney, can't do it. Does that answer your question? So yes, you can resign, which brings me to another quick point. If you're going to appoint somebody on your powers of attorney, ask them if they want to do it. Because if they say no, and you didn't have any backups, now you don't have a power of attorney and you might need a guardianship. Did that answer your question? Okay, but you can have an out-of-state person named as the attorney, in fact, and we can talk a little bit afterwards too, just to make sure. Yes. You are not. So if you're somebody's power of attorney or attorney in fact, you are not liable for their bills personally. I mean, you have to pay their bills for them out of their funds, but if there isn't enough funds to pay that, then no, you are not personally responsible for this. Yep, they could still do that. Yes.
If you have a living will and a power of attorney, which precedes the power of attorney or the living will?
It depends. So that living will only kicks in if you're brain dead or in a terminal condition with no chance of recovery and death is likely to occur soon. Until that point in time, your healthcare power of attorney is what controls. So right now, you're fine making all of your own decisions. End of life, over here, like my dad, brain cancer, was going to die soon. His living will kicked in. You have this big gap in the middle. This big gap in the middle is filled by your healthcare power of attorney. So you make decisions until you can't anymore. Your healthcare power of attorney then makes decisions until brain dead or terminally ill. Then your living will kicks in. Good question. Yes. So, ooh, that's a. Then don't have a living will. If you have a living will, they are legally obligated to follow that living will. If you want them to have to check with your family members before, then don't have a living will and have a family member designated to make that decision for you. In the living will, if you take a look at that document, there is a thing in there that says, here's who I would want you to contact, and excuse the saying, before you would pull the plug, for example. So you can name your kids in there, and then the hospital would try to call them before they would do that, but they don't have to check with them to see if it's okay. They would try to get a hold of them so they could be there with you. But if you have that living will, it can't be overridden by your power of attorney. With the living will, 2 doctors have to have examined you and agree that you're brain dead or that you're in a terminal condition with no chance of recovery. So 2 docs have to have done that and signed off on it before the living will kicks in. Real quick, I know I'm out of time. Something to think about. I call it kind of the forgotten generation when it comes to powers of attorney. I mentioned I have 3 kids. 2 of my kids are adults, and they're off at college now. Because I am who I am, when they were getting ready to leave for school, they were both 18. I sat down and had them sign a healthcare power of attorney and a financial power of attorney appointing me and my wife as their decision makers. Why? Because when your kid turns 18, who gets to make all of their decisions for them? They do. You might hold the checkbook for that tuition, but they get to make all of their decisions for themselves. So once they turn 18, they're an adult, they make their decisions. God willing, nothing would happen, but if one of my kids is in an accident and they need healthcare decisions made for them, if I didn't have a healthcare power of attorney where they appointed me, I would have to get guardianship over my own child to make decisions for that child. So have them fill out a healthcare power of attorney. Kids, grandkids, nieces and nephews, or whomever, they have to be 18 and competent and able to sign it. I know whether an 18-year-old is competent is a question in and of itself, but they do have to have a healthcare power of attorney, so keep that in mind. I always like to mention that. So we go around and do this presentation throughout the county just like I did today. We do it because we want you to make these decisions. I want you to decide who your executor is going to be. I want you to decide who's going to make your healthcare decisions for you and your financial decisions for you. I want you to do that. If you don't have these documents in place, someone else, like the chief magistrate at the probate court, makes those decisions. Who's going to be the executor? Who's going to be the guardian? We, unfortunately, we're tasked with that job. We don't want to have to make those decisions for you, which is why we hand these documents out so that you make those decisions for you. We want you to make them, so you do it. I always mention this too. I don't know what the next big holiday is. We'll say Thanksgiving. What I want you to do at your next Thanksgiving when all your family's there is say, let's talk about how we're all going to die someday. No. It's a great conversation starter. But part of this is communication, right? Talk about with your family what it is you want. I try to inject a little humor in it to make it a little more comfortable so we're not talking all doom and gloom and we have a little bit of fun with it. So if you have a group that you would want us to come talk to in your materials, is Tara Kirscher. She is our what are you again? Community outreach coordinator. Contact her. We do schedule these. If you have, another church group or you're in an art club or a book club, we just ask you to try to have about 20 people there. So you guys are overachievers. There's like 50 here. Awesome crowd too, by the way. Thank you. But we're willing to come out and do this presentation for others. So if you're going to have Thanksgiving, I'm happy to come to Thanksgiving and talk. No, I'm just kidding. And bring my family. They all have to come. So they'll be home from college, so it'll be 5 of us. But no, seriously, we're happy to come do the presentation at other groups. If you have other people that you would want to have, we have extra copies. Everything that we gave you today is on our website. So if you have other questions, I'll be here for a little bit afterwards. Feel free to come on up and ask. And if I don't see any other hands, one more. It's her fault we're still here. Yeah, I recommend that you go to an attorney to have it done just because of the power of that document. We don't hand them out because when you sign that document, obviously, you're handing your keys to your financial kingdom to somebody else and saying, spend my money for me. So we don't hand those out because of that. I recommend that you go to an attorney to have it. You can find forms online. I've already mentioned the danger of those forms. Another quick example of that, I've seen it like 4 or 5 times now. There is a will out there, an online wills.com will. I don't know if that's the actual site, but it's online. It says it's an Ohio will. And on it, it says this: when I die, I leave my property to, and then it says first beneficiary, second beneficiary, third beneficiary, fourth beneficiary. I have like 4 cases right now with that exact same will that people are getting offline. Does that mean I have my 3 kids and I list them 1, 2, 3? Does that mean I want it divided equally between the 3 of them? Or did I name the first beneficiary to get it? And if he doesn't, then my daughter gets it. And if she doesn't, my other son. I don't know. So now I have to have a hearing to determine what that person meant when they signed that will. That's just an illustration of what can happen if you don't have that legal help when you're filling these forms out. Yes?
On the financial power of attorney, say I get one done and I give it to the person that I quote trust, are they able to go in and execute any transaction without my knowledge?
So the question was, if he has a financial power of attorney, can that person take that document and go in and execute any financial transaction on his behalf? It depends. Financial powers of attorney can be written in a multitude of ways. One is you sign it now and it takes effect now, and yes, they could do that. Another one is it happens like the healthcare power of attorney. It doesn't kick in until you can't make the decision for yourself. With powers of attorney, what I would do in that situation, I'd put in the power of attorney. 2 doctors have determined I can't make this decision anymore, and then whoever it is can make those decisions for me. The issue with that is, obviously, if I can't make that decision, I have to get me to 2 doctors to give an opinion that I can't do it anymore. And then they would have to show those opinions to the bank before you could use that financial power of attorney. So there's pros and cons, and there's different ways to do it. One more quick horror story. I had a client met with me, came into my office and said, my house is being foreclosed on. And I said, oh, I'm sorry to hear that. He said, yeah, but I didn't know. And I go, well, what do you mean? He said, my wife and I were married for 23 years. I had a financial power of attorney that named her power of attorney. What I didn't know is she had an alcohol and gambling problem. She took a mortgage out on our house and blew it at the, I don't know, remember if it was a dog tracker casino. Blew the money, didn't pay the mortgage. He found out that she had a gambling problem when they served him with foreclosure paperwork. So kind of a horror story as to what can happen with those financial powers of attorney. Again, 99% of the time that doesn't happen, but that is something and why we don't just hand them out. So you just have somebody filling them out on their own. Yes. It is not. This is just for informational purposes for your executor.
Say in my will that I have a value, let's go for a car. Okay, I have a car. And I don't have anything in my will about that car. But I made a note in here where that car should go.
Doesn't count. No. If you have a will in Ohio, it has to be signed and dated at the end. Somewhere in that document, you have to state, this is a will and I know that I'm leaving my property to somebody. And it has to be signed at the end with 2 witnesses. So 2 witnesses has to have seen you sign it, and you see the witnesses sign afterwards as well. So if you just write in that document, here's who I want to get it, it wouldn't be legally enforceable. It could be, yeah. That would do it too, yes, if you had a transfer on death title. Most people don't. Yeah, that's a relatively newer thing in the law, so a lot of people don't. Yeah. Right. Yeah, it's definitely good. Is the title fee. Yeah. Is it 17? I know it used to be 12, it's 17 now. All right, well again, thank you all for having me. I appreciate it. Thank you.
Wow, that was mind-blowing. That was a lot of notes we were taking there, so thank you so much.
Presentation a couple weeks ago, and a guy came up to me afterwards, and he goes, I thought I was ready to die until I heard you today.
I know. I mean, you feel like things are in order, but I'm not so sure now. So let's give him one more hand. Thank you. Thank you so much for being here. Thank you. Thank you, everybody, for coming and for being here. And I hope this was very beneficial. I'm sure. I know for my own personal time now that was really gave me a lot of information. There's plenty of refreshments. Please take a piece of pie home and some different things, or some coffee and different things over there. So take something home with you and have a great week, great weekend. So,